thank you all for joining us for the webinar, Compliance with New Jersey's Wage and Hour Laws and What Nonprofit Employers Need to Know. Nonprofits are employers just like any other business, so we have to follow all of those same requirements as employers. We also, my name is Debbie Duncan. I am the Director of Education Services here at the center. I've been here for 18 years. Doesn't seem possible. I help with help desk requests. We share resources, professional, if you need professional assistance in a wide variety of areas. And then, of course, these webinars and workshops. And finally, we do have a conference at the first week in December. I'll be telling you a little bit more about that. What does the center do? We are here to support New Jersey's 501c3 charitable nonprofits. We provide, most important and least visible, we provide advocacy. We meet with legislators. We talk with a lot of different groups in the community and other umbrella organizations. We learn about what issues are affecting nonprofits, what's positive, what's negative. We educate our legislators, and we try to get them to make changes in either policy or legislation to benefit the sector. And then, of course, we educate the nonprofits about all of that. We do some research. We have on our website, we have a variety of different publications that you may want to take a look at, as well as just, help assistance for nonprofits. Education, this type of training, we have, as I mentioned, the help desk that we provide advice to people. If you have a particular question, contact us first. We may not have the answer, but we'll get you to the people who do. We are a membership organization, and our members get certain benefits. They get discounts. They get, more in-depth service and free job postings, things like that. But we're here to serve everybody. We don't turn anybody away. Membership is a way of supporting us and getting extra benefits for your organization. Then I want you to understand that we're here in New Jersey, but we belong to the National Council of Nonprofits, and there are sister organizations of ours all over the country. So wherever you go, if you move yourself, if you have colleagues in other states, let them know that they can contact these other organizations with information that is state specific for them. A lot of stuff is national, but every state has their own requirements and regulations and hoops to jump through. So let me introduce Nicole Jacoby. She is the Community Outreach and Planning Specialist for the New Jersey Department of Labor and Workforce Development's Wage and Hour Division. We have asked her to update us. There have been a lot of changes in laws in the last months and year or two. So we have asked her to please help us understand what those changes are and share with our nonprofit employing community.
So welcome everyone to our presentation today. The title of our talk is called Compliance with New Jersey's Wage and Hour Laws, specifically what nonprofits need to know. And just want to welcome you in again. We're so excited to have you join us. If you could please just introduce yourself in the chat if you'd like to, just as an icebreaker. You can share your name, your nonprofit organization, your role there, just to give us a sense of like who you are and, what kind of work that you do too. Feel free to add that. And then we have a little discussion question. We just want to know, what topic are you most interested in learning about during our presentation today? So to give you a few examples, we're going to cover the minimum wage, overtime, earned sick leave. We're going to talk a little bit about independent contractors. We're also going to talk about volunteers. We're going to talk about earned sick leave. So just a few topics out there. There's some topics that we don't cover in the Division of Wage and Hour Compliance. That's going to be a little bit outside of our purview. So I'll let you know if I see any that are outside of our purview. But we can always help connect you with others. Just note that this presentation is intended as a general information only, and it does not carry the force of legal opinion. So this is just for your education, your knowledge. It's not legal advice. the laws and regulations can change very quickly. So it may be out of date if you look at this, a few months from now. Things can change pretty quickly. So just stay up to date. I know the Center for Nonprofits does a great job with their advocacy and just making sure that you get those legislative updates, and we'll make sure to share information with them too that they can share back with you. The New Jersey statutes and New Jersey Administrative Code should be consulted for the most accurate and up-to-date legal information. So that's the laws themselves. We actually have them on our website too, and you can peruse that. A lot of it's written in legal language that can be kind of difficult to understand at times. So the goal of this presentation is to put that in more plain language. We enforce laws to protect all workers regardless of legal status. An employer cannot withhold payment because an employee does not have a valid Social Security number or because an employee has not completed a W-4 or an I-9 form. And a last note that employers must not retaliate against their workers for exercising their rights or inquiring about their work rights. New Jersey has very strong protections for workers, and we want to make sure that all employers are in compliance. As I mentioned before, the New Jersey Department of Labor is a very big department. We provide many different kinds of programs and services. First and foremost, in my opinion, because I work for the Wage and Hour Division, is worker protections, making sure they get paid correctly. We also have a division that enforces health and safety protections. They also provide education and outreach to help ensure that employers are in compliance with health and safety protections. Career services, we also have business representatives in each county that could meet with you and help direct you towards some hiring and training grant programs. If you need to hire some new workers, if you have some staffing issues and you need to get some more people to help with your organization, they're a great resource. Labor market information, that's our data people. They make sure that we're understanding those trends in different kinds of industries. We're tracking unemployment rates. So we get a lot of great information from them. We also have insurance programs like disability insurance, family leave insurance, unemployment insurance, and Social Security, disability, and more. So that kind of social safety net that helps make sure that workers are staying safe and healthy, and if they're protected if they need to, leave work or anything like that. We also have workers' compensation too that provides those kinds of insurance protections. So with the New Jersey Department of Labor Wage and Hour Division, today we're really going to focus on the minimum wage, record keeping, the methods of wage payment, overtime, earned sick leave, misclassification, and anti-retaliation. Now, these aren't all of the laws that we enforce. There's, I think there's probably over 20 laws that we enforce. I think I'm even lowballing that number there. But these are really the hot topics that we get a lot of questions about from employers. So we really want to make sure that we're focusing on this. We're going a little bit more in depth to help explain it in a way that's accessible for you. And our goal is really to educate employers so that we can prevent violations in the future. We feel that giving you this knowledge and this information and trying to help clarify any questions that are out there can really be a way to prevent violations and help keep you guys, out of trouble if there's any violations or anything like that. We want to prevent that before it happens. So knowledge is power, and we want to make sure that you're empowered to be in compliance with the law and that you have everything that you need to implement policies that are compliant with wage and hour laws in New Jersey. This slide I think is really important. I think this is a really good, summary of the presentation, like a one-pager that you can refer back to, and just get a sense of the employer responsibilities under New Jersey's wage and hour laws. So the employer is responsible for maintaining records showing payroll, hours, wages, benefits, commissions, etc., paying employees at least the New Jersey minimum wage, paying employees overtime when applicable, paying employees their wages regularly, which means at least twice a month, not taking illegal deductions from paychecks, permitting employees to earn and take earned sick leave, not coercing or retaliating against workers if they have a wage complaint, following specific rules for workers under 18 years old, properly classifying their employees, and carrying workers' compensation insurance. So this is just a one-page summary of, I think, probably the most pressing employer responsibilities under New Jersey's wage and hour laws. Feel free to refer back to this slide, and we're going to go a little bit deeper into most of these topics that are listed here. And we're going to start with the minimum wage. So for most employers in New Jersey, as of January 1st, 2024, the minimum wage is $15.13 per hour. Now, there's a few different categories that you'll see here. For seasonal and small employers defined as fewer than 6 employees. That rate is $13.73 per hour. For agricultural employers, it's $12.81 per hour. And the cash wage for tipped workers is $5.26 per hour. The wage for long-term care facility direct care staff members is $18.13 per hour. Now, the minimum wage, it's currently over $15, and it may continue to increase each year on January 1st, but it's tied to a measure of inflation. That measure is called the Consumer Price Index. So the department will be evaluating throughout the rest of the year if there's going to be an increase for next year based on the Consumer Price Index. So as we get towards the end of the year, the department will be, sending out press releases, making sure that people are aware of whether that minimum wage rate is going to be increasing for next year. So we'll make sure to share that information with the Center for Nonprofits once that comes out. Hasn't been determined quite yet. It's usually a little bit later on in the year, in the fall, just to kind of get people ready for when the increase is going to take effect. Increases usually take effect on January 1st. New Year's Day is a good way to remember it. And you'll see for the past few years, it's been going up each year, but now that it's exceeded $15, it's tied to the Consumer Price Index. So we're still in a wait and see pattern for now to see if it's going to increase next year. But we're going to go through a few of these different categories and just kind of dig a little bit deeper. So we'll start with the small employer. And you must meet these following 2 requirements to be considered a small employer. And this really depends on the number of employees that you have. So during the current calendar year, you have fewer than 6 employees for every working day during the majority of the work weeks. And during the previous calendar year, you had fewer than 6 employees for every working day during at least 48 calendar work weeks. In 2024, the minimum wage for small employers is $13.73 per hour. The key thing here is the fewer than 6 employees. So 5 or less employees, you could be considered a small employer. But once you have 6 or more employees, you would be subject to that minimum wage rate, the $15.13 that applies to most employers.
Can I just interrupt a second, Nicole?
Go ahead.
Is that
Yeah,
full-time employees or
that's a
full-time
good question.
equivalents?
That's a good question. I need to look into that a little bit more deeply. I believe it's full-time, but I want to make sure I get you the right answer on that to see how part-time might play into it. But generally fewer than 6 employees. But I want to just clarify the part-time piece of it for Debbie and the rest of our audience. But that's a great question. Okay, for seasonal employers, it's $13.73 per hour as well, which is the same rate as the small employer. But this is defined a bit differently. It really depends on the time frame when your business is open throughout the year. So a seasonal employer cannot be an employer that's open all year. You have 3 options here. You can meet any of these 3 requirements. So first is that services are provided only in a 10-week period in June, July, August, and September. Or during the previous calendar year, at least 2/3 of gross receipts received in a continuous 16-week period, or in the previous calendar year, at least 75% of wages paid were for work performed during a single calendar quarter. So very, very concise time period here that's listed in these 3 options. It does not include labor on a farm. And the 2024 minimum wage is $13.73 per hour, just to reiterate that again. Okay, the next category is tipped workers. So the cash wage plus tips must equal at least the minimum wage per hour. If that combination is under minimum wage, then the employer must make up the difference. In 2024, the cash wage is currently $5.26 per hour, and employers can claim a $9.87 tip credit. However, if an employer fails to pay the minimum cash wage, they can't use a tip credit and they would need to pay the full minimum wage. When an employer takes a tip credit, overtime is calculated on the full minimum hourly wage, not the lower cash wage payment. And we have a lot of great information on our website here specific to tipped workers. So if that applies to your organization, if you have any tipped workers, please feel free to check that out. So there's a lot of great information on our website too. Okay, moving away from the minimum wage, we're going to talk about record keeping. Record keeping is really essential to, managing an organization. Just having everything documented and organized is so key. So we really want to make sure that employers, whether it's business owners, nonprofits, understand that record keeping is essential to compliance. In your records, you need to be including the name of the employee, their address, their rate of pay, gross and net wages, itemized deductions, their mode of payment, the check date or pay date, and the earned and used sick leave. Just to reiterate again, employers must keep records. We can't say it enough. Employers need to keep daily and weekly records of the exact hours their employees work each day and within a week. Time records must be true and accurate to the work performed by an employee. Wage and hour records must be kept for 6 years. So make sure you're documenting everything you can with those requirements we talked about in the last slide, and keep those records organized, have them ready, be updating them regularly. The wage payment law and paycheck deductions. So an employer must notify their employees of their rate of pay and their regular payday upon their time of hiring. Notify employees of any changes in their rates of pay or paydays prior to those changes taking effect. Provide employees with a statement of deductions for each pay period. It's really important. Even employees that are paid in cash, they have to have that statement of deductions. Always have a statement of deductions for each pay for all your employees. And employers must also pay wages on regular pay days, which makes sense. Employees need to know, when they're being paid. It needs to come regularly so that they can plan and have the money that they need. So yeah, just really important to notify employees if there's any changes in the rate of pay before those changes take effect. You can't retroactively decrease their payment after they've already put in the work. Employers cannot withhold wages or make illegal deductions if an employee puts in the work. If they're actually working, any time that they work must be paid. We also want to emphasize too that nonprofit organizations are not exempt from payroll taxes. You also have to be making sure that you're, making those deductions as required by state law. We have an example, a little picture here of a paycheck. At the top, you can see the earnings, you see the overtime, the straight time, which is just the regular time excluding overtime, and the paid time off. That's all broken out into different categories. I think that's a good idea, just to make sure that employees understand, when they're being paid for overtime, how many hours they worked overtime versus how much is straight time, and then also to see their paid time off too, to know how much they've been using, how much they've accrued throughout the year. At the bottom, you see the payroll deductions. And those are those payroll taxes I had mentioned before. Really important to make sure you have that statement of deductions that really clearly lays out the different kinds of payroll taxes that are on a paycheck. Next, we're going to talk about overtime. So overtime pay for an hourly employee must be 1.5 times the employee's regular rate of pay for every hour worked over 40 hours per week. Employers can require employees to work overtime. In that case, the employer must pay the appropriate overtime rate. The employer and the employee cannot together agree to violate the state overtime laws. So when that employee works more than 40 hours a week, starting with the 41st hour, they must be paid for the proper overtime rate. So 40 hours a week is really important for overtime. We get a lot of questions about my employee worked 41 hours the first week, but then 39 hours the second week. Do I have to pay them overtime because it's 80 hours over a 2-week period? Yes, for the first week, since they worked 41 hours, they have to be paid that one overtime hour. It's really key. Starting with that 41st hour in a week, they must be paid the proper overtime rate. Overtime is a hot topic right now. There's been some changes from the federal Department of Labor that we're going to talk about. And we just really want to make sure everybody's up to date on some of these new rules that have gone into effect from the US Department of Labor that also apply in New Jersey. For overtime, there's a few exemptions for salaried employees. Hourly employees have to be paid overtime. Salaried employees, there's 2 kinds. There's those that are exempt from overtime and those that are not exempt from overtime. If they're not exempt from overtime, they have to be paid time and a half for hours worked over 40 in a week. The exemptions, in order to be considered exempt from overtime, there's very specific rules to this. So we want to make sure all employers understand this. an employee must meet the individual criteria for the specific exemption claimed. So there's very specific categories that apply to these overtime exemptions. This includes executive, professional, administrative, outside sales, skilled mechanics, limousine drivers, certain trucking industry employees, labor on a farm engaged in agricultural work, computer professionals, etc. And it should be noted that exemptions should be claimed and granted. So what does this mean? If you're claiming, say, the administrative exemption, you need to go back and look at the Federal Fair Labor Standards Act, which is from the US Department of Labor. And within that law, it lays out the requirements to meet that exemption. So we're going to talk about that in the next few slides, but it's really specific. It includes salary basis, that the person is being paid with a salary, that they make a minimum weekly salary amount. That's the threshold to be exempt from overtime. And then also that they meet the specific job duties that are laid out in the Fair Labor Standards Act for that specific exemption. So if you're claiming an exemption, you need to be specific about which exemption you're claiming. And you need to be really sure that that employee performs those job duties that go along with that exemption. It's not enough just to have the title. They have to be performing the job duties and make that minimum salary level. So to dig a little deeper here, this very common misconception, just because an employee is salaried or has the title of manager does not mean they're exempt from overtime. So all overtime exemptions must meet the requirements of the Federal Fair Labor Standards Act. As I said before, it's the salaried basis. They're getting a guaranteed fixed salary, the minimum weekly salary level, weekly again, very important for overtime, and job duties. They have to be making that, or they have to be performing specific job duties that apply to that exemption. And this new rule that I'm going to talk about from the US Department of Labor took effect on July 1st, 2024. So it's still pretty new. It increased the minimum weekly salary threshold for overtime exemptions, and the rule also applies in New Jersey. So this is the new overtime rule. It took effect July 1st, so it's currently in effect. And we're going to talk about the earnings threshold. So the standard weekly salary level. So right now, the one that took effect in July is that employees must be making at least $844 per week to be exempted from overtime. This equals out to $43,888 annually. Now it's going to increase again on January 1st, 2025. It's going to go up to $1,128 weekly, which equals out to $58,656 annually. And then starting on January 1st, 2027, and every 3 years after, the USDOL will adjust the salary thresholds based on updated wage data. So you can find more information on this website here from the US Department of Labor. They also have a great webinar too that really goes into detail about those specific categories I mentioned. So you can learn more about the administrative exemption and the professional exemption, managerial exemption, to get a sense of like what those job duties are and how to kind of determine if your employees might fit into those categories if this applies to you. But it's really important to mention that this new rule only affected the salary level part of the test. So it didn't change any of the job duties or anything else about the overtime rule, just really that salary threshold. And then also with these overtime exemptions, you need to make sure you're meeting all of the requirements. So you have to meet the job duties and you also have to meet the standard salary level and make sure that they're being paid a fixed salary. Salary basis is what it's called in the law. So it's really important that you're meeting all of those requirements. And it's a very specific process. Like there's rules to the overtime exemptions. We want to make sure employers understand these rules and understand where to get this information. Also, when I share out these slides, there's another category for exemptions for highly compensated employees. They have a few different rules for that. That might be also relevant to some of the nonprofits here. So I put some notes in the chat when I share out the slides that link to the US Department of Labor's information about the highly compensated employees too. We're not going to dig into that here, but you can find more information from the USDOL about the highly compensated employees too. I just want to note this is a brand new rule. There's been a few challenges in a few different states. The rule is currently in effect in most states in New Jersey. I think there's maybe one legal challenge in Texas, but it's very limited. But for now, it's still in effect. If there are any changes that would come through like legislative updates or judicial updates, it'd be shared out through the U.S. Department of Labor, shared out through different organizations like the Center for Nonprofits. We'd make sure to share information with you as well if anything changes. But for now, just remember this is in effect. We haven't heard anything that it's going to be changing in New Jersey anytime soon. So just make sure that you're following these rules. But that's why it's so important. As we said before, this presentation could change in the future. So this is something to look out for and just keep up to date if this applies to your organization, that there could be changes. But for now, it's in effect, and we need all employers to comply with the new overtime rule. Okay, so another hot topic is earned sick leave, and it is the law in New Jersey. It recently went into effect about 5 years ago. We want to make sure all employers are complying. So full-time, part-time, temporary workers, and minors are all eligible. The law applies to employers of all sizes. Workers accrue 1 hour of sick leave for every 30 hours worked, and that's up to a maximum of 40 hours in a year. Or the employer can decide to provide employees with 40 hours of leave up front. Existing paid time off, PTO, policies used to satisfy earned sick leave must meet or exceed the law's requirements. Employees can use sick time to care for themselves or a family member, and the definition of family under the law is very generous. It could be used for physical and mental illness or wellness care, to cope with domestic or sexual violence, to attend a meeting at a child's school if it's requested by a school staff member. For employers, an employer can require 7 days advance notice when the employee has planned to use sick leave. So this would be a case of a doctor's appointment or checkup. An employee knows that it's coming up, they're able to plan for it, they could provide you with advance notice if you require that. If an employee's need for earned sick leave can't be planned, you could require the employee to give you notice as soon as it's practical. So that would be like waking up with a fever. You weren't expecting that the night before, and you wake up and you really don't feel good. You can't come into work. You have to call in and tell your employer when you wake up, as soon as it's practical, that you're not going to be able to make it into work today because you're sick and that you want to take earned sick leave. Employers cannot retaliate against employees for requesting or using earned sick leave. An employer is not permitted to require an employee to find coverage when using earned sick leave or to make up the hours. And we have a great resource. It's called mysickdays.nj.gov. Has a lot of frequently asked questions for employers. So we really recommend that you check that out. And if you have any questions, the answer might be there, but if you have any additional questions, feel free to reach out to us too. For record keeping, earned sick leave is a little bit different than other wage and hour laws. So the law specifically for earned sick leave says that records must be kept and maintained for 5 years. Documenting compliance, this includes hours worked, earned sick leave accrued in advance, used, paid out, and carried over. And the records must be made available to NJDOL if we request it. Earned sick leave record keeping is for 5 years is the requirement. Typically for wage and hour laws, the requirement is 6 years for record keeping for minimum wage and other kinds of wage and hour laws. Might be good to keep it for 6 years just in case, but the law only requires 5 years of record keeping for earned sick leave. We wish they would have made it consistent, but unfortunately they didn't when they wrote the law. So we just want to make that distinction for you. Employers must give each employee written notice of their right to earn sick leave. And this includes how to accrue and use sick leave and the right to file a complaint and be free from retaliation. We want to make sure that employees know about earned sick leave so that they can use it when they need it. Employers must display the NJDOL earned sick leave poster where all employees can see it, and that can be downloaded for free on our website. I'm going to show you that poster in just a few slides. Unused sick leave can be carried over or bought back by the employer at the end of the year. And up to 40 hours can be carried over for a benefit year. And this is what the poster looks like. So all employers are required to display this poster where all employees can see it. You can download and print out this copy for free, and it's on our website, which is listed here. There's also other posters that are required for employers to have at their work site, such as a minimum wage poster, record keeping poster, and that's all at our website here. So you can just print them all out for free and just hang them up with a thumbtack and just make sure that you're in compliance with that poster requirement. You can also share it online on a employee intranet or something like that, just to make sure everybody has access to it. Okay, our next topic is misclassification, and this is the practice of not properly classifying a worker as an employee. This is typically the difference between an independent contractor versus an employee. This can take the form of identifying the worker as an independent contractor or simply not identifying the worker as either an employee or independent contractor by paying the worker off the books. Misclassification is a really hot topic right now. New Jersey uses a really strict standard that's called the ABC test. There's 3 requirements within the ABC test that an employer has to meet all 3 of them to truly determine that a worker is an independent contractor and not an employee. The standard is very high and the penalties are very strict. If an employer gets that wrong, we really want to make sure that employers, understand this law and that they're confident in knowing whether their worker is an independent contractor versus an employee, so that they stay on the right side of that equation, because we don't want anyone to get confused, and there's really high penalties. Misclassification, it can really harm workers because they're not paying into that kind of, the employer themselves is not paying into unemployment insurance and workers' compensation, depriving them of the benefits that if that worker gets injured or harmed, that they'd be able to benefit from those social safety net systems. So misclassification is really important. We typically see this with like the gig economy, where there sometimes tends to be questions about who's independent and who is truly an employee. And then also workers that get paid in cash where there's no records. If a worker gets paid in cash, there needs to be a statement of deductions. So we just want to make sure that that's clear. I can share out some more information too about the ABC test and the differences between independent contractors and employees. But just wanted to give a mention here because this has been a really hot topic around the country. So, New Jersey has very strict laws against misclassification. We're going to dig a little deeper into some special considerations for nonprofit employers. I'm not going to read every word on the slide here, but these are just referring you to the definitions of an employer, an employee, just so that kind of hitting that same point that nonprofit employers are still considered an employer the same way as a for-profit business in New Jersey. So you can read through these definitions. You can see where this is cited in the actual law, just to give you some background on where all this comes from. And I want to mention volunteers too, because they're different than employees. A volunteer is a person who donates his or her charitable service for the protection of health and safety of the public. This could include, but it's not limited to, volunteer firemen, rescue workers, aides in the care of the sick, aged, young, or mentally ill, or assistance in religious, educational, hospital, or cultural activities. And I think this last point is really critical. Paid employees of a nonprofit organization cannot volunteer to provide the same services that they're already employed to provide. So it's really important to make a clear distinction between your volunteers and your employees so that there's no confusion there, no blurred lines. We need to make sure that they're staying separate. So a few scenarios here to help make this a little bit more clear. Individuals generally may not volunteer in commercial activities run by a nonprofit. This could be selling merchandise or partnering with a for-profit business for an event. A volunteer is not entitled to compensation if the individual volunteers freely, without the expectation of compensation, on a part-time basis, and without displacing or performing the duties of a regularly employed worker. Just make sure you keep your boundaries clear there between volunteers and employees so that everything makes sense and everything's distinct from each other. We also want to talk about sheltered workshops, just to give them a brief mention. Nonprofit organizations may apply for a sheltered workshop permit to employ individuals with disabilities for less than minimum wage for a fixed period of time. So here's a picture of what the sheltered workshop permit would look like. It's available on our website. These permit applications are handled by our division, Wage and Hour Compliance. So you'd fill out this form, it would get sent to our office and we'd review it and let you know if you're eligible for a permit, if you're interested in a sheltered workshop permit. Also want to give a plug to our DVRS unit, the New Jersey Division of Vocational and Rehabilitation Services, DVRS. Not sure if anybody's worked with them before, if you ever heard of them, but their mission is to enable eligible individuals with disabilities to achieve an employment outcome that's consistent with their strengths, priorities, needs, abilities, and capabilities. They have field offices in each county, and they have business outreach teams that provide support to sheltered workshops. They help employers strengthen their businesses, enhance career opportunities for individuals with disabilities. They can help you with job placement or career counseling. So just a really good thing to take advantage of if this applies to you. If you want to learn more about their services, you can complete the online referral form, which I have a link to in the slides. So when I share it out, you'll be able to click on that link and learn some more. Okay, just to sum everything up. So we talked about what the laws say, how employers can comply with the laws, but if there are any violations, an employee can file a complaint in case of improper record keeping, failure to pay minimum wage and overtime, illegal deductions, failure to provide payment for earned sick leave, misclassification, retaliation, which could include threats or actual acts of retaliation. Just talking about legal deductions for a quick second. I didn't dig into this as deeply on the slide that had the paycheck on it, but some examples of illegal deductions could include breakage, spillage, uniforms. Really, the taxes are the deductions that are legal, that you have to make sure that are taken out of that paycheck, those payroll taxes. But illegal deductions are a different category, which would be that breakage, spillage, uniforms that you're not allowed to deduct. So payroll taxes have to be deducted. Those other kinds of deductions are illegal, should not be deducted from wages. And in our last few slides, we're just going to talk about retaliation. So retaliation occurs when an employer penalizes an employee for asserting certain workplace-related rights, such as the right to be paid minimum wage or paid sick time. Retaliation could take many forms, including but not limited to getting fired, a poor performance review, changed salary, increased oversight on job duties, changed workplace responsibilities, being denied a raise or promotion. So we just want to emphasize that workers have a right to learn about their rights, to question how those rights are applied to them, to report violations of those rights, and to demand those rights without interference from their employer in asserting those rights. Workers are protected against retaliation under both state and federal law. So we just want to make sure that workers are aware of their rights, they know what they're entitled to, and that employers are also encouraging them to use their sick leave, making sure they're being paid the correct wage and being paid for the correct hours. Okay, so that's all I've got for today. Thank you so much for your attention and for your interest in joining this webinar. And we can open it up for questions to see what kind of topics piqued your interest while we were talking.
This is great. Thank you so much, Nicole. That's a lot of information, right? And again, I want to reassure people. You will be getting both a recording of this webinar, and you will be getting a copy of the slides. So, don't feel you have to knock yourself out trying to write everything down.
Yeah, absolutely. It'd be a lot of notes to take. So
right.
Just reassured you'll get the slides and you can refer back to it.
Okay, we do have quite a few questions here. Thank you all for putting questions in the Q&A. This has worked really well.
Awesome.
If it says if this doesn't come up under the overtime section, I'm interested in the intersection of the New Jersey laws and the new federal requirements around minimums for salaried employees and paying out overtime pay if an employee doesn't reach the threshold. And I think you kind of answered that, but you might as well reaffirm.
Yeah, I think just to reassure. So the new overtime rule also applies in New Jersey. So our overtime rules, for the most part, mirror what the federal Department of Labor lays out there. So the new overtime thresholds also apply in New Jersey. So the thresholds have been raised from the previous level. It's already into effect, and then it's going to increase again January 1st. So you just want to make sure that you're staying up to date with that in January. If you have overtime employees or exempt overtime employees that would apply to.
Okay. Is the payroll record retention 6 years plus the current fiscal year, or 6 years including the current year?
That's a good question. I'll have to look into that. That one's a little more detailed than my knowledge of what the law says. I'd have to dig in a little bit deeper to see how we apply it.
Okay.
I think each business I know the state we have our own fiscal year, federal, they have their own fiscal year. Each business might have their own distinct fiscal year. So it might depend on what the fiscal year is for that specific business, the way that you set up your finances. But I'll look into that.
Great, terrific. Thank you for asking that question, Rory.
Yeah, thank you, Rory.
Okay. Is record keeping for the time worked different for salaried employees? Do we need to keep records of daily hours for employees who are salaried and not hourly as well?
So for salaried employees, it depends on that overtime exempt versus non-exempt. If they're not exempt, yes, you have to keep records. If they're not exempt, they have to be paid overtime if they work over 40 hours in a week. So you really want to pay attention to those exemptions. I think for exempt employees, the record keeping I don't think is as strict because they're exempt from overtime, but I think it's always a good idea just to keep records as much as you can. I would always err on the side of caution. Keep as much records as you can so that if there's ever any questions, you have something to refer back to. Also recommend having like an employee handbook or some kind of guide about your policies. It's not required by law, but I just think having documentation is always a good way to cover your bases. So just to kind of reiterate that, going back to the original question, if the salaried employee is not exempt from overtime, you got to keep those records. If they are exempt, it's a little bit more relaxed because you're not tracking those hours as much because they don't have to be paid overtime, but that's provided that they meet those really specific requirements. So just make sure you're up to date on those requirements of the overtime exemptions and you're following that new rule that was just implemented in July. So does that answer the question?
I think it does.
Cool.
Um,
All right.
do
Sounds
you
good.
do you have I was going to say maybe
Yes,
how to
yes,
help us.
absolutely. I definitely recommend watching that one. That one helped
Mhm.
me learn a lot about the new overtime rule, and I used a lot of the same information in my slide. I'm going to have a link in the slides. It'll be in the notes, the speaker
Okay.
notes.
Okay.
So you can just click
Great.
that link. It's like a 30-minute webinar, not too long. You can just breeze through it and just learn a little bit more about that new rule. But definitely
Okay.
recommend
Terrific.
like keeping up on the news, especially the courts, Supreme Court, state courts, about that new overtime rule because things may change, but for now it's in effect. So we need everybody to comply.
Okay. Terrific. And that will be in the follow-up letter
Yes.
too. So I try to pull out all the links and duplicate them. Okay. Another question is where did you say I could find the info on highly compensated employees?
Yep, same thing. That would be the USDOL webinar. That's going
Okay.
to be in the slides.
Okay.
They have a few slides just about that, the highly compensated employees. And that might apply if your board is hiring a new executive director or somebody who's really highly compensated for a nonprofit for that kind of management. For highly compensated employees, I will say that the requirements, the strongest requirement is that salary level. They're a little bit more relaxed on the job duties. I think it's implied if you're making that high of a salary, you're overseeing, staff, you have a managerial role. It really focuses on that salary level more than the job duties for the highly compensated. But for all other overtime exemptions for regular employees that are not highly compensated, you have to meet all those requirements. So you have to check all the boxes.
Great. Okay, if you have a fully virtual office, how can the organization properly hang the posters? And can these digital posters be shared to employees on a shared computer system, perhaps?
Yeah, that's a great question. We live in
Yeah,
the 21st century.
yeah.
We're coming out of that post-COVID world where there's a lot of work from home and, some offices are completely remote now. I think, as I said in the presentation, probably your best course of action is to do like an intranet, like share it on a remote network. Really, the key is to make sure everyone has access to it. So as much as you can get that poster out there, you have it, accessible to any employee. If you don't have a physical office location, if you have a network that everyone has access to and they can, get that poster when they need it, that's really key. So just use your computer networks that are accessible to everyone to get that poster out there. And just really
Okay.
important for your new employees to make sure that they know where to find that information when they start.
No, that's a good point. I mean, when I think about at our office, we have, a large portion of a wall covered with all of the different posters
Yes,
and
there's a
things.
lot of posters.
So,
I think there's like 13 posters,
yeah,
and they're all on our website. So
yeah.
you can print them all out. I know there's some services online where they'll like consolidate the posters. So you have all 10 plus posters in one giant poster. But you can also print them out for free online and not have to pay, for any service. It's really up to you with your convenience, what you prefer.
Yeah, that's what
And
I
you can
was.
do it remotely too online if you don't have a physical office location. Just make sure everyone has access to it.
Okay, that's great. I was going to add a caveat to, be careful of all these people that charge money for it,
Exactly,
because
exactly.
unless it's, as
Free
you
is always
said,
in the budget, so
right. Yes.
just requires some ink and some
Yeah.
paper. But
Yeah.
if
Yeah.
you have it already, you can go for it.
Right. All right. If we already have sick worked into our part-time PTO, do we have to add in an hour for every 30 hours worked on top of that?
That's a good question. I want to look into that a little bit deeper. I think the key thing for employers that we run into with this question is employers should really be denoting either in like their handbook or their employee policies whether PTO is separate from earned sick leave. That tends to be the first question we ask. Um, so we really want to make sure that that the way that employers are setting up this policy, it clearly denotes whether they're lumping in the earned sick leave with the PTO or if there's two separate policies. You could do it either way, but we just want to know, so when we're looking at the records, whether it's all together or whether it's separate. But let me look into that a little bit more deeply just so I get you the right information for that specific situation. But always helpful for us to just denote if it's lumped in together or if it's two separate policies.
Great, thank you, thank you. Can you give some examples of improper records keeping?
Yeah, that's a good question. I'm trying to think off the top of my head. Probably just common sense things about like not listing the the wage that an employee's making, not separating out hours between overtime and straight time, just having it all lumped together and all paid at straight time when it really should be broken out and the overtime should be paid at a premium rate. A lot of the issues, unfortunately, that we see with record keeping is employers not keeping records at all, which is really difficult for the employers specifically, because if there is a wage and hour audit, we need to look at that documentation. And if an employee complains and that's where the investigation is coming from, we're going to have to ask the employer for their records. And if the employer doesn't have their records, we only have the employee's word. So it's really difficult for us to substantiate both sides if we don't have the records from the employer. And it's so critical. The law really spells out that record keeping is the responsibility of the employer. So an employee, they can keep their own journal, they can keep their own records, but it's not their responsibility. That's just to cover them. But employers need to be covering themselves and complying with the law and making sure that they have those records. So I would say one of the biggest problems we see is no records, which is really unfortunate for the employer because we need to be able to see that's their best case to show that they are complying with the law and that they are keeping track of things. I think a lot of these violations stem from not keeping records. So I would just recommend, as we said on the slide, make sure you have the employee's name, check date, pay date, their address, all of those different requirements, just to make sure that that's all clearly listed out there.
That's great. The other thing I would mention, we always recommend people consult with an accountant to make just, even reviewing your records to see how they're set up every
Yeah,
once in a while. So, if you have questions, it might be worth just asking a professional to come in, look over your records and do kind of an evaluation or give you some recommendations about
absolutely.
improving.
I also want to mention too, because we talked about employees who may be paid in cash. Um, that's a big problem for records keeping too. If there's no statement of deductions, or if there's no record of them being paid. If you have anybody who's being paid in cash, make sure that you're giving them that statement of deductions for the payroll taxes and make sure that they are that you have a record that they've been paid. Because if they claim that they haven't been paid and they got paid in cash and there's no records, we really want to make sure that you have those documents to say, no, I did pay them. Like here's the evidence.
Yeah, that's very good. Good. That's very important. I forgot to mention too that if you are looking for any kind of professional services, including accounting or legal or marketing or whatever, at the center we have lists of people who are experienced working with the nonprofit sector and understand the needs of the nonprofit sector. So don't hesitate to reach out to us and ask us if we can direct you to service providers that have that experience. Okay, the next question is, must organizations allow rollover of unused sick time, or can the organization have a use it or lose it policy?
So that's at the discretion of the employer. You could either allow it to roll over or you could buy it out at the end of the year. I'll get you some more details about how that works at the end of the benefit year. The benefit year is the 12-month period. It doesn't have to be a calendar month, but just a calendar year. It doesn't have to be January through December, but it's a 12-month period that you can set up for your earned sick leave time where your employees will accrue. And then at the end of the year, there's a few different options for if they're going to roll it over, if you're going to buy it back from them. So let me get you some more details about how that works specifically. But the employer has discretion of whether they can buy it out or they can roll it over to the next year.
But what I'm hearing you say, I think, is that they
Yeah.
can't just say you lose it.
Yeah,
Correct?
I'm gonna get some more details on
Okay.
that. I think it's either buyout or I think it's either buyout or roll it over.
Okay.
Let me get some more details because they've earned that sick leave at that point. There's a few other pieces to it as well. If they go to a different organization, like do they carry their sick leave with them? I'll get you some more information about
Okay.
how that works at the end of the benefit year because there's a few different scenarios and I want to lay them out pretty clearly for everyone in the follow-up document.
Fantastic.
Debbie,
Okay.
this is
Yeah.
Kathy. I'm sorry to interrupt. There are a few participants who've noted that they're having trouble hearing you, and you are much quieter when I'm listening than Nicole is. So I don't know
Oh,
if your
okay.
mic might
Let me
not be
turn up
connected.
my.
Thank you.
Thank you. Okay. Does the employer have discretion in determining the number of hours per week that constitute full-time employment to qualify for health care and other benefits? Or is there a law that addresses this? I've heard some employees are considering full-time when working 25, 30, 32, or 35 hours per week.
Yeah, it's a good question too. I think this is outside of our purview for wage and hour, but we can look into this and see if there's another agency that might handle this or another law. I don't think it's specific to wage and hour for healthcare and benefits outside of like earned sick leave. We don't regulate fringe benefits and things outside of just those 40 earned sick leave hours in a year. So we'll look into that and see which law addresses that and if there's a state agency that might be able to give you some more information.
That's a great question because I have noticed that, but don't.
Yeah.
Yeah, interesting. Okay, great. Okay, contracts that you have through the state or feds, you have to have everything documented. I think this is more of a comment that
Yeah, and you can correct me if
contracts.
I'm wrong, Megan. I think this might also be applying to like I know a lot of nonprofits are grantees and they receive money from the state or the federal government through grant programs. And a lot of the times with these grant programs, you have to submit documentation of your payroll and your records to substantiate the salaries that you're providing through the grant program to different staff. I used to be a grant manager myself, and I remember seeing that. I used to work at the Department of Law and Public Safety, and we'd have to check the payroll records. So it's really important if you do receive any kind of grant or tax credit, any kind of public money, make sure you're in compliance with labor laws because that could be something that's reviewed. Anything through like the EDA or different kinds of grants. We really want to make sure like public money is being used, responsibly and sustainably, and workers are getting paid correctly if they're receiving public money.
Great, thank you. Is there an hourly minimum for part-time salaried employees?
That's a good question. I'm seeing part-time employees come up a lot in some of these questions.
Well,
Um,
yeah.
that's a good question. I want to break that down a little bit more because generally for most employees in New Jersey, it's that minimum wage, $15.13. It really depends on what kind of employer they work for, if they fall into any of those different categories, if the rate is different. I'll have to look into that a little bit more. I want to unpack that a bit, just make sure I'm reading everything
Sure.
correctly. But I think it would be the same minimum wage for part-time. Salaried employees that's throwing me off a little bit, so I need to unpack that a
Right.
bit.
Okay, fantastic. These are good questions. I told you our people are
These are good
sharp.
questions. You guys are
Yes.
keeping me on my toes.
Okay. Uh, requirements of your pay source, are they different than labor law requirements?
Requirements of your pay source. I guess that probably goes back again to like where the money's coming from. If you're getting a grant or a tax credit, something like that. Um, yeah, I guess it depends what kind of program you're under and what the strictest standard is. Like if you're getting federal money, usually when there's a difference between the US Department of Labor and the New Jersey Department of Labor, the highest standard applies. It could be different. I don't think like Davis-Bacon or prevailing wage would apply in many of these cases, but that would depend on where the money's coming from, the pay source, as Megan had said. So just be aware of your program. Usually, just from my background knowledge with grants, usually that's in the terms and conditions of the grant program is, you know, the labor requirements that are expected or different kinds of laws that you have to follow and the rules of that grant program. So I would just really refer back to that grant program to understand what's expected from that source you're getting the money from. But typically it's the strictest standard applies if there's a difference between USDOL and NJDOL. Like our minimum wage is a lot higher. It's almost double the federal minimum wage. So in that case, the New Jersey's labor law applies. Same with earned sick leave. They don't have earned sick leave at the federal level. So in New Jersey, that's the one that takes precedence. Some of the child labor stuff, child labor laws, kind of in some cases, the New Jersey law is what takes precedence. In some cases, it's the USDOL law that takes precedent. The overtime comes from the USDOL because New Jersey's law adopted a lot of those requirements from the federal law. So sometimes it can be a bit confusing to navigate those two different levels. Federalism is always a great topic, difference between the federal government, state government, and local government. But typically the highest standard will apply. So whichever law is more strict and provides more protection to the worker.
And again, let me just add to sometimes we're reluctant to contact governments, and you do want to make sure you reach somebody who's knowledgeable, et cetera. But don't hesitate to reach out to the Department of Labor, both on the state and the federal level, and also again consult. You can consult with an accountant. There's also Pro Bono Partnership is a service for 501c3s that offers free legal guidance and services, and this is the kind of thing they might do on a help desk basis, just to help you kind of see what the where you're falling. Two more questions. What are your thoughts on paper timesheets?
That's up to the employer. I'm not a payroll professional, so I'm not here to make those decisions for you. I would just say if you're keeping paper timesheets, have a very organized file, make sure that you have backup records because, sometimes paper can get lost or, something erroneously gets thrown out. So it might be good to just have a backup, even if you want to keep paper, but then, scan it and have an electronic version, or if you want to just have like a second file just in case. But I could imagine those paper costs would get quite to be a lot with all the printing and the timing of scanning. But it's really up to you what you prefer. But I would just say have a backup just in case. That would be my recommendation. I also put my email in the chat in case anybody wants to contact me, as Debbie was saying too. Feel free to reach out. I'm separate from enforcement in the Division of Wage and Hour Compliance, so you can reach out to me if you have a question, and you can feel free to just kind of keep things general, keep things vague, and just my job is really just to provide information. So we're not going to provide you with legal advice or any kind of like specific case by case, here's what you should do. But we can tell you where to get the information and help explain the law to you if there's confusion. But we know some people, feel a little nervous about reaching out to government agencies, or it can be kind of daunting to look at all this information and, try to reach out to a government agency. Sometimes it's not as responsive. So even if you guys want to send questions through Debbie and Kathy to send to me, we can do that too. If you feel better with like an intermediate or if you have like a accountant or a payroll professional that you can ask too. That's always great support as well. Just make sure that your payroll professional knows what they're doing, because
Yes.
if the records that you provide them with are wrong, they're not going to fix them for you. It has to be right when you're doing it. They'll help you organize it, but they won't help you get it right. They might have some compliance information, but don't think that they're just an end all be all, that you're going to be in compliance if you use a payroll system. They can help, but they can't get you all the way.
All right. This is incredible amount of information here. Last question here is, can you require a salaried employee to work a minimum of 80 hours biweekly? And if that is not met, then supplement with PTO. We're not touching their salary, but just their PTO.
That's a good question. I'm going to look into that a little bit
Mhm.
more just to make sure I'm getting all the details right. Um, my gut feeling is this is probably discretion of the employer. To see 80 hours biweekly. Salaried always depends on whether they're exempt or non-exempt. So 80 hours biweekly, like I said, if it's 41 hours the first week and 39 the next week, that first week is going to require overtime. So you really want to be aware of, if they're not exempt from overtime, what hours are they putting in per week?
All right. I don't know, Kathy
Oh,
or
and I just
Kyle.
want to add to
Yeah,
that. I
sure.
just remembered for that last question. Overtime is based on hours actually worked. So with the PTO, if an
Ah,
employee works like 40 hours in a week, but then they're taking like 8 hours of PTO, you don't have to pay them overtime for the PTO. It's just that the 40 hours is like their regular hourly rate. It's not, 8 hours of overtime because they went over 40. They didn't work those 8 hours. It was PTO. It's time actually worked is for the overtime. I hope that helps clarify too, but we'll make sure we look into that a little bit more. But it really depends also on whether they're exempt or non-exempt as a salaried employee.
okay, we've dealt with our questions, and I just wanted to invite everybody who's on this. If you are not a member of the center, we are offering a discount code. You can go into our membership enrollment and enter horse NJ, all one word, and it will give you a 10% discount. I want everybody to check our events page. We have programs that we offer ourselves, like this one, but we also list a lot of other education programs, professional development programs for nonprofits. So keep an eye out on that, because there's a lot going on. And if you have an event that you know of or you're offering that has to do with helping nonprofit staff and volunteers, let us know about it and we'll list it. A couple of things that are coming up on August 29th next week is the Grennan Foundation is offering a new way forward on wellness at work. This is a series of free webinars they've been offering that is really very helpful, and there are recordings on their website. Another one that might be of interest is the support center is offering effective delegation. That's always a challenge for employers. That's another event you might want to consider. And finally, save the date. Wednesday, December 4th is the Center for Nonprofits annual New Jersey Nonprofits Conference. We are going to open registration, and we'll be opening it to members first, so that members have an opportunity to register at our early bird rate. And then we'll be opening it to the public probably 2 or 3 weeks after that. Anyway, but it is a fantastic conference. I may be blowing my own horn, but darn it, it really is. Finally, Nicole, I want to thank you so much for doing this. This is so important and valuable to the nonprofits in New Jersey that are employers. And here is your contact
Mhm.
information. Please feel free to reach out to Nicole if you have questions. And I have a link to the general page, the wage and hour page. But in the follow-up, we'll have some more information about